Okay, this is a video for an update. I said I'd do an update video when I got the notice of issue file paperwork back from the court. I've had that today, and I'm just really showing people that the court's now acknowledged that there is a claim. It has been issued. I'm just going to take us through it. It basically says the claim was issued on the 31st of October 2017. The court sent it to the defendant by first-class post on the 31st of October 2017, and it will be deemed to be served on the 5th of November 2017. The defendant has until the 19th of November 2017 to reply. So obviously it's against the company, we're the claimant. It's about Section 19, and it's the Office of the Traffic Commissioner and Wigan Council. Issue fee was £185, and you can see that the defendant is going to do one of three things, really. He's not going to not reply at all. They're not going to pay. They will either file an acknowledgement of service that gives them from 14 days up to 28 days from the date of service of the particulars of claim to file a defence or contest the court's jurisdiction. They may dispute the whole claim and they'll file a defence, or they'll admit that the money's owed. They're not going to do that because there's two defendants. Admit that only part of your claim is owed. They're not going to do that either. Oi! Tilly, behave. So what's going to happen is they're going to either file an acknowledgement of service or file a defence, one or the other. Now, I don't think they're going to file if they file a defence, they're going to have a problem, because this is the claim form and there's nothing really significant in here. It just talks about we claimed 5,000 at this point because I don't have the information to populate the value of the claim. £185 court fee, and it just says see the particulars of claim. And now on the particulars of claim, I've redrafted this. On the previous video, it says I showed what I was using for a draft. I've now got my claim number, which you can see at the top. And you can see that claimant's us, Traffic Commissioner is the first defendant, Wigan Council is the second. I'm going to take you through this pretty quick so that you can just get to see it. The claims for negligence against both defendants. Both defendants owe the claimant a duty of care, breach the duty of care, and cause the claimant a loss. The claimant is in the business of providing blah blah blah. First defendant's blah blah blah. Second defendant's blah blah blah. The relevant law in this matter is European Regulation 1071/2009 attached. Now I didn't attach it in the particulars of claim to the court because I didn't have it to attach to this online document, which is what I've sent to them. But specifically Articles 1, 2, 3, 6 and 7 of that regulation. As it's a regulation, it's directly applicable in all member states, and the right to enforce this regulation of the claimant arises from this regulation itself. That means that we can do something about it in court. Exactly what we do in court is the debate. Letters before action were sent out, but the first defendants did not even respond to it. Traffic Commissioner did not respond to the letter before claim. The second defendant asserted their compliance with what they had described as a grey area of law. The particulars of negligence. Both defendants owe the claimant a duty of care, as both defendants are likely to injure the claimant if they do not apply Regulation 1071/2009, as it is the regulation specifically in place to govern the provision of home to school contracts. And then I've cited the regulation. Basically, this is the law, and I'm going to use this. I'm going to show you this because this is really quite important. See if I can make this a little bit bigger. There we go. The general provisions of this 1071. This regulation shall apply to all undertakings established in the community which are engaged in the occupation of road transport operator. It shall also apply to undertakings which intend to engage in the occupation of road transport operator. So remember the second part. It's all undertakings, but it's all intentional undertakings as well. Undertaking is that it means any natural person or legal person, whether profit-making or not, any association or group of persons without legal personality, whether profit-making or not, or any official body, whether having its own legal personality or being dependent upon an authority having such personality, engaged in the transport of passengers, or any natural or legal person engaged in the transport of freight with a commercial purpose. Now, this is where the community transports fit into it, because community transport is supposed to be not-for-profit. The English call it charitable. They say that the money that they earn is not considered profit because it's charitable funds. That's what their defence is probably going to be. So it means any natural person, any legal person, whether profit-making or not. So it doesn't matter whether they're making profit or not. Any association or group of persons without legal personality, whether profit-making or not, or any official body, whether having its own legal personality or being dependent upon an authority having such personality, so long as they're engaged in the transport of passengers, the regulation applies, whether it's profit-making or not. So it doesn't matter whether it's profit making or not. It doesn't matter whether the funds are considered charitable or not. As long as they're engaged in the transportation of passengers, then this regulation applies. Commercial purpose, key phrase. The tendering process is commercial. So they're not going to be able to get out of it. Now they're going to argue that the derogations apply, but they're not going to be able to argue that because we'll come to it in a bit. Because the regulation applies, the articles of this regulation also apply, namely the provisions from Articles 3 to 8 not produced. Any award of any tendered contract of service by the Council's own word in competition satisfies the definition of undertaking, as it is commercial by any definition. Therefore, inclusion of any 19 or 22 permit holder is unlawful, as they cannot abide by the further requirements of the regulation. That is what kills them. It's also worth noting that the regulation does not apply to the award of tendered contracts. Not only apply to the award of tender contracts, it also applies to undertakings which merely intend on engaging in the occupation. Remember, that's the second part of the. It shall also apply to undertakings which intend to engage in the occupation of road transport operator. This means the regulation applies at the application stage onto the tendered contracts lists, not just the award stage. So it's before they get to the point where they're awarded contracts. It's being on that list. This is a key point to observe, because the effect of allowing 1922 permit holders to even tender for contracts is that it artificially lowers the ability to attain fair profits, because the tenders from 1922s are usually much lower than the operators, as they usually get state funding, usually get state grants, as is the case here, and it creates an anti-competitive practice. This is why both defendants are responsible. This process should be policed by the first defendant, but isn't at all. It is being used to artificially force prices down and is anti-competitive. Tendered contracts are therefore legally ring-fenced to only operators, not operators pretending to be charitable by nature. This kills them. Really bad kills them. Because the transport industry is heavily policed by the first defendants on the grounds of passenger safety, fair profits are needed by operators to be able to maintain high levels of safety. Conversely, by failing to police the competitive market, the first defendants are actually forcing operators to work for minimal or next to nothing for profit, and that's why so many operators have left the industry in the last 5 years. This is where I need help from operators that have gone under in the last 5 years or so, because it's been on since 2010, 2009, 2010. We know that operators have gone by the wayside. I don't know who they are, but if you know an operator that has gone by the wayside because of the competition that these Section 19 permit holders are abusing, please get in touch with me, because I want a witness statement from you to that effect so I can present it to court and make this point a key point. If I've got 5-10 people that say I was put out of business by 19 permit operations, that's going to devastate them, because it is anti-competitive. In 2016, the claimant applied for numerous contracts, but numerous contracts were awarded to holders of 19 permits in breach of Regulation 1071/2009, Article 1. This year, 2017, claimant applied for 54 contracts, but numerous contracts were awarded to holders in Section 19 permits in breach of Regulation 1071. In awarding contracts to holders of permits, the second defendant breached Article 1 of Regulation 1071/2009. In failing to police the tender contracts, the DVSA also failed its duty to maintain fair competition. And there's an extract from the website of the DVSA. To encourage all operators, which will be the council, because they're operating these, they're doing it by proxy, by third party, and we're also operators too, to adopt robust systems so that there is a fair competition, and they're not doing it. So this is the Traffic Commissioner's priorities: fair competition. They're not doing it. Further, the DVSA, Traffic Commissioner, failed to ensure the regulation was adhered to. The claimant suffered a loss by both defendants' failure to abide by 1071, and claims for the loss of profits it would have had the contracts not have been awarded to holders of Section 19 permits. It is not known how much of a loss the claimant has suffered at the time of issue, because the second defendants, the council, have failed to provide information from a Freedom of Information request of the claimant, an offence under the Freedom of Information Act. An application to quantify this claim will be needed after disclosure and inspection, but before allocation, as the matter may well be a High Court matter due to the realistic value of the loss. If not a specific application, certainly a key point at case management conference. The second defendant's failings under the Freedom of Information Act have caused this consequence. They're not going to want this to go to court, because that's going to kill them. The claimant was most surprised to see tendered routes appear in round 2 of the tender process that it had applied for in round 1 of the tender process. This work was meant to go to the next lowest price tender. of which the claimant must have been the next lowest price tender, otherwise it couldn't have been retendered. So what had happened was round one, routes 1, 2, 3, 4, 5 were tendered by everybody, and then routes 1, 2, 3, 4, 5 that we tendered for appeared in round 2. So we were like, hang on a minute, why have they been retendered at round 2 when we were obviously available and we didn't get the work? I'm pretty sure that they're not meant to do that, because we tendered for it in the first instance. We didn't even get it. So whatever went on, I want to know where that work's gone. I want to know who got those rounds that we tendered for. So the particulars of loss. The claimant tendered for contracts at a daily rate of 190. This rate did not rise from the previous year, even though the pensions and minimum wage changes are upon us. The less the running cost per day of around 50%, and the claimant was expected to receive around 95 per day profit. This is taking into account the common factors such as wage, fuel, wear and tear, tax contributions, insurance tax, annual inspections, etc. The claimant intended on operating not more than 8 vehicles for the council that year, the same amount in previous years. Breakdown is as follows. So basically, if we were to put 8 vehicles on at 95 day of profit, 760 a day profit, 5 weeks, 3.5 a year, 37 weeks for the duration of the contract, roughly 140,000. Now, obviously, we're not going to have got all that work. We may only have got 5, 6, 8. We might have only got 1, but I want to know where the other work went. The claimant agrees it may not have attained all 8 vehicles on contracts, but it avers that the work that was retendered in round 2 was work that should have been awarded in round 1, in addition to the work awarded to permit holders. If it turns out that the work that was retendered in round 2 went to permit holders, that's specifically work that we should have had that they should not have had. If it went to other operators for whatever reason, that may well be fair competition. In any event, I want to know where that work went, because that's an issue. The claimant is particularly interested to see if any of those retendered routes were awarded to 19 or 22 permit holders, because if it did, that's fucked. In any event, the decision to allow 19 permit holders into the tender process and awards of contracts to Section 19 permits breached Article 1, and the claimant claims damages for loss of profits on that basis. Conclusion. Historically, and this is what people forget, I've been in the game for long enough to know, and most people have too. Historically, and by the Act itself, the Transport Act of 1985 provided redress for rural areas that had a shortage of operators to be able to provide non-commercial services so that vulnerable members of society could still be mobile. Wigan is not rural, nor does it have a shortage of operators. There really is no place for any Section 19 permits in Wigan. What it does have is Section 19 permit holders abusing the law and the governing body doing absolutely nothing about it. It intends to rely on the manifestly absurd decision not to prosecute Swadlincote Community Transport, even though it was accepted that the rules were broken. For those that aren't aware, Swadlincote in Derbyshire were stopped by the DVSA. None of them had driver's CPCs, on a Section 19 permit on a school run. They accepted that the rules were being broken, but they were not punished. It seems that a Section 19 permit is a badge of immunity of law, and the first defendants are turning a blind eye. Not acceptable. Whilst the claimant believes the decision to award tender contracts is an undertaking for the purpose of the regulation, and that no Section 19 permit holder is allowed to even apply to be on the tendered list, the view of the claimant is that the council is simply taking advantage of the failings of the regulatory body to police the application of the regulation. The view of the claimant is that the council is simply taking advantage of the failings of the regulatory body to police the application of the regulation is the real issue. The claimant relies on the recent conclusions of the infraction proceedings from the European Commission against the UK for their failings to apply this regulation in full. The claimant also seeks to rely on the official reason given in writing of Beverly Bell for leaving her office as Traffic Commissioner. The claimant believes this reason was directly because of the Department of Transport specifically curtailing the actions of the DVSA in regards to Section 19 policing. Specific disclosure of this document will be expected for the judge to consider. The urban myth is that Beverly Bell left because she knew that the Section 19 permit was not being policed and the DVSA were not allowed to touch it because the DFT told them not to. So I'm going to cite this in court for the judge to see, and I want everyone to be aware that this document's going to be pleaded in a court case to show that the DVSA are being scaremongers. And then there we go, signed it off. Now, this is bad stuff. Bad stuff. These people need to be stopped. I really, really, really need to appeal to people out there. If you know of anybody that lost their business, had to shut down because of these people, because of these people, get in touch with me, please, because I need to get statements from anybody that lost their business because of Section 19 permit abuse. I'm going to wrap this video up now because I'm done. But pass this round, let operators see it. It's really important. When I find out what their defence is, I'll do another video. It's going to be interesting. So keep tabs, let the word go round, but I need to get in touch with people that lost their business. I'll speak to you soon.